Already comes to soon, she's on the bench already. She's running out of cases. Right.
He's first on the list. It's fine.
Is he first on the list? Is he first on the list?
That's the judge. That's the judge.
You got a media case in there too.
We don't care.
Keller, you're here first. You want this to have been before the big case.
I got Prince over in Gorilla at 9 o'clock exactly. What? He's up there.
So you want to come back? You can come back.
Bananas. Bananas. Soda. Soda. Yeah.
Who's this other guy?
Right there.
Who?
Tracer.
Oh, hell.
Yeah.
We're supposed to start.
You better come back later.
Oh, that's okay. Okay, don't take my guy out though.
Miss
I'm gonna go Barello
Go back in
and
9:30.
print them and by the time they finish the thing, I'm ready.
Mr. Holler, you can do that.
Huh?
I just told you we're supposed to.
I'm gonna get one of this. So y'all know, my last daughter graduated college.
Oh, congratulations.
I didn't say it was on. Look, I'm regretting the decision that Peter did. Cut into it. Right, let it play in the morning while I get dressed. I'm not sure I know what I'm pitching. These kids be driving these streets, right? I told my, I said, you were super early this morning. Yeah,
Castro makes a distinction between the Fitzpatrick case, where there is some governing law that says that a state attorney's office can be isolated in certain respects, where a particular prosecutor is removed, but not the entire office is removed. And there's a body of case law. We went over that, and I'm not going to rehash that at all in this argument. But in the Castro case, they found that that body of law did not apply. And, and they read, however, we cannot say the same result should follow where the defendant or the public at large is given reason to believe the judicial process has been compromised. Our judicial system is only effective when its integrity is above suspicion. And I want to highlight the words used already in this opinion, because the reason is suspicion and the public at large has been given just reason, okay? And then it says, our system must not only refuse to tolerate impropriety, but even the appearance of impropriety as well. An imagined advantage on one side or the other in a criminal proceeding can be as destructive of the integrity of the process as can be a real advantage. So if you go back through what has happened in this case, the public at large and Mr. Fernandez especially cannot walk away from this without suspicion that the integrity of this judicial process has been compromised. A email with what we deem are privileged information was forwarded to other members of the state attorney's office, and I learned today, and sometimes when you're the litigator, you don't absorb all of the testimony. I did not know until Ms. Stifler was on the stand this morning that it was a possibility, or now perhaps even a probability, that Lindsay Butler had read her the entire document. So the idea that she hadn't laid eyes on it, I mean, her testimony, and I had the advantage of re-listening to it, was that she said, I never laid eyeballs on it. I didn't read it. That is it's irrelevant. That's like someone saying, I didn't look at it, but call me immediately and read the entire thing to me. It's the exact same thing as reading it. There is no difference between someone being read the document and reading the document. So respectfully, as to whether she read it or didn't read it, it was read to her, or at least her testimony was, it may have been read to her in its absolute entirety, or perhaps just enough for her to determine it wasn't important. And then when she forwards it to Mr. Mizrahi and she forwards it to Mr. Wingard, there's nothing in the body to suggest that they should not read it. And Mr. Mizrahi says that he has not, but that's not the standard. The standard from the Castro case is the appearance that he may have read it, or could have read it, or forgot. I mean, there is a lot of information in this case. Mr. Mizrahi mentions that there's a lot of information, and he candidly told the court that he didn't recall receiving this document. Well, maybe he didn't recall reading it, but who's to say he won't at some point recall how it could be useful? How him knowing what Mr. Fernandez told us in a timeline could be useful to their prosecution? There's no way for the court to determine that. And that's why the standard is not whether they intend to use it, whether they used it, whether I can prove perhaps that detectives or other members of the state attorney's office read those documents. I can't always do that, but that's not the standard. The standard is whether or not the public at large believes the integrity could have been compromised. And with that, Your Honor, what we have put in our PowerPoint is whether or not the prosecutor personally assisting in any capacity, which of course Ms. Stifler is assisting, and Mr. Mizrahi is assisting, and Mr. Wingard is assisting, in the prosecution of the charge, it would call for the disqualification of the entire firm. Thank you.
Thank you. Mr. Cody.
Your Honor, it's Ms. Gardner's position that Exhibits 18 and 19, as well as the testimony we heard today, demonstrate this continuous course of conduct by the state that has shown a lack of concern for these defendants' rights. We want to remind the court that in February there was this court order that ratified the use of a taint team On February 27th, 2023, there was a meeting with all the players on the state's team about the devices and the taint process. That included the state attorney's office, the Jacksonville Beach Police Department, the ATF, and the Secret Service. They were told they could not go into the devices without the taint team reviewing it. They then went out and got these defendants' clouds. And you had the testimony at the last hearing from Ms. Stifler that on or about May 11, 2023, she becomes aware that ATF analyst Butler is reviewing Ms. Gardner's iCloud iMessages. And Ms. Stifler was clear to this court. She told them to cease and desist. She made herself out to be this protector of rights and this good actor, and that the state was very concerned about protecting these defendants' rights. And that is May 11th of 2023. Well, what do we know and what was added to at this hearing today is that the next month in June, the state attorney's office is determining themselves whether or not the privilege applies for Mr. Fernandez. And then they are forwarding docs to each other that are titled confidential. And then, according to Ms. Stifler, she was read the timeline doc but didn't read it herself. And I submit, Your Honor, that that is a point without any distinction whatsoever. And the fact that the state even tried to make that distinction to the court, that it was read to her but they didn't read it themselves, Your Honor, shows that there's nefarious conduct on their part, and they know it. Overall, what this court has heard over the days of these evidentiary hearings is that the state engaged, and by state I mean their team, including the ATF and the Jacksonville Beach Police Department, engaged in reckless and grossly negligent conduct, and there is a clear appearance of impropriety that warrants a remedy. And we gave the court some options for those remedies. We believe that at minimum the court should exclude Ms. Gardner's iMessages regardless of the source, as that is at least a proportionate sanction for their reckless and gross negligent conduct with regard to handling information that they knew contained attorney-client communications. Thank you, Your Honor.
Thank you. Ms. Romney?
Yeah, first of all, with regard to Ms. Gardner, again, just to reiterate, we have never, ever laid eyes on any attorney-client privileged information in that case. And as soon as we found out that police officers were going through things that could be potentially attorney-client privilege, we stopped it immediately and put it through a tank team. With regard to the arguments that both counsels made about the state arguing that hearing about the contents of the timeline and reading about the contents of the timeline were an argument that the state made, I must have not been present. The state has never made that argument. We have told the facts of the case, which is that Ms. Stifler never read the timeline, but we never uttered an argument saying that that was a distinction. We acknowledge that Ms. Stifler has the information contained within the timeline, as she does with regard to the text messages between the defendant and his co-defendant. So that's not an argument we're making. What I would point out is that the remedy that the defense is asking for is so burdensome and onerous on the state of Florida for a number of reasons. One, the people, the citizens of this jurisdiction have elected Melissa Nelson to be their state attorney to prosecute these cases, and removing her is obviously the court has the power to do it, but it has to be very cautious in the judicial branch affecting the executive branch and the legislative branch, which you have the power to do, but you have to be careful to do with the separation of powers. Number two, Ms. Stifler has worked thousands of hours on this case, and no one could ever replace the amount of work that she has put into this case, whether it be within our office or from a different office. And that would be a loss to the citizens of this jurisdiction. The email that we sent finally today, or last week, about the receipt, I agree with Mr. Dreiser that the whole point of seeing that email was to indicate that those documents were forwarded because the state had represented to this court that we had not reviewed those documents. I still maintain, and I've in discussions with Mr. Wingard, neither one of us has a memory of ever reviewing those documents. But certainly they were forwarded to us, as is countless numbers of bits of information that are in this case. So I don't see a situation under which Ms. Stifler could be removed and other people in the state attorney's office could not. We discussed this case over the last years in roundtables and discussions, and we acknowledge that bits and pieces of information are passed around that we may have no memory of. And as I say here today, I am confident that I have never read either one of those documents, but certainly they were forwarded to me, they were forwarded to Mr. Wingard, and there's a possibility that they were open. How do I remember that? We tried to figure out forensically, and we could not at this time. But regardless, our arguments are that they're not privileged. These are, again, documents that contained in the Google Cloud that were not attorney-client communications. And even if they were, the remedy is not to discharge the state attorney's office, but perhaps they are not admissible pieces of evidence. And that's something that the court will decide. Unless you have any more questions, that's all the argument.
So there's basically, based on the forward, there is a concession by the state of Florida that that information was at least available and potentially communicated to Ms. Stifler. And so you think, based upon that concession, you're not saying that there shouldn't be any remedy for the defense. Your suggestion is suppression or exclusion.
I'm saying, suggesting there should be no remedy in this case, number one. Number two, yes, because again, I'm not privy to whether it's our attorney-client privilege, and they claim they are. If the court determines that they're attorney-client privilege information, and the court determines that that is a fact in this case, then certainly the court can suppress the use of those pieces of evidence. So that is certainly a remedy that would make sure that the public is confident in the application of justice.
So address the argument made by the defense that the appearance of impropriety, how would that ever be remedied by mere, because if it was communicated or if it was potentially known by the state of Florida, how would mere exclusion rectify that?
That's where the totality of the facts of this case come in, the countless hours and the countless effort that the state of Florida did to protect defendants who were not under arrest, who had not been charged, who had gone out and hired lawyers, that had used devices that were sharing information with the entire world, Google, iCloud, and then using the attorney-client privilege somehow as a sword to prohibit the state of Florida from going through potentially incriminating evidence, is not violating the public trust in any way, shape, or form. We did everything we could to ensure that we did not look at attorney-client privilege information. These two documents, only, let's be very clear, the only two things the state of Florida has ever looked at are these two documents. One was read, one was looked at. That these two documents were not in any communication whatsoever that we were aware of. They were saved into a Google Drive, and they were labeled not attorney-client communications, they were labeled confidential and confidential. And so how can the public then say, oh, well, you should have known that these documents in the cloud were attorney-client privilege? When we discover later that they're attorney-client privilege, just like if we served a search warrant in a house and picked up a document and said, oh, we were looking for the contract for this murder, but this is a contract of an attorney and a client. We looked at it, we read it, we put it down, the court says you can't use that. That doesn't disqualify an office. So that's the distinction. The court can support the public trust if this is attorney-client privilege that we were not aware of, suppress it.
I'm going to go to the case that Mr. Sullivan cited at the last hearing, while not reported, while a federal case. The Sullivan case seems to suggest a method for review of potentially agree to heighten non-review of the information. So I would like for you to reconcile for me how, if you agree and gave the defense the assurance that you would not even look, which I'm not even saying that agents couldn't have if they were outside the jurisdiction and followed such procedure, even though in Sullivan the court is critical of that process. Explain to me and reconcile for me, you just argued to me that by saving whatever these documents are, either attorney-client privilege or not, they are in fact sharing it with the world. Why would the state agree to a heightened standard, not review, but then potentially search without any reference to a taint team or anything? And then, are you making that distinction that because it was saved on a Google Drive, that you all could just operate as your own taint team? Is that what you're saying to me?
Well, first of all, yes, we could have done all of these. We could have searched the phones without this agreement.
Right.
Right. We tried to do something better, which tries to get save the public trust. The problem is that we were doing two different things. So when we had this, as they refer to, a ratified agreement on the phones, that is what law enforcement thought. Oh, this is to the phones, and we did that whole procedure. When we did additional searches on the clouds, it did not occur to them to do that, or to us initially.
Did it occur to the state?
It did. As soon as the state was aware that they were searching these without the taint team, we stopped. The answer is yes. It did occur to us. But I do think
In
there's...
federal court, according to the Sullivan case, the taint procedure is presented to the magistrate who approves the warrants. So the warrants were going through the court system. The warrant would include what would be on the devices. My understanding of the testimony from Ms. Stifler is the devices potentially more, and that's why the state was going for it. That it would potentially contain messages that might have been deleted from the devices.
Specifically,
themselves.
the ring camera footage and
Ring.
things. Yes, that's what we're looking at.
Things that were deleted, or things that were beyond what had been agreed to the devices. So I'm trying to reconcile like what the argument is that, are you saying because it was on a Google Drive that the taint agents weren't applicable from the state's perspective?
There was never a court order with regard to this. What I'm
Right,
saying...
because there was an agreement between
Correct.
parties, and it was in a footnote.
Correct, as to the phones. All I'm doing, we never wanted to say, hey, we're gonna search the Google Drives or the iClouds to try to do an end around to this agreement. That was never the intent. It was a distinction, and that distinction led to the police searching the clouds, and then when we became aware of it, we stopped it. It's as simple as that. This was not an end around to try to get around the phones. And again, that's the whole point of this whole concept of prejudice. What prejudice is there? What evidence is there that we're going to use in this prosecution? What knowledge do we have that's going to change any of this? This is unlike federal cases where they're serving. This is a unique situation where we're investigating a murder case and the people have hired lawyers. And then in today's world, we have this Google information that stores everything. And we're trying to find probative information, which we did, in those deleted, taint team documents. And Google Clouds, we found very probative information in this case with regard to the planning and plotting of the murder of Jared Bridegan.
Okay,
And that is, this is a balancing test of the state's interest and the interest of attorney-client privilege, and we tried to do both. We did the best we could.
okay, and the distinction, I just want to be clear, so the distinction is that you believe the agreement was only to the devices, because, and if I'm understanding the timeline, they knew about the devices because warrants were served, the devices were seized. However, the defense would never know about the state's investigation into a cloud because those things are specifically not communicated to defendants so that they don't go and delete things from the cloud. So they would not, that is the defense, would never have the ability to seek the protective orders that they did for the devices because they had no knowledge of it.
Correct, that's all
So
true.
then it would be incumbent upon the state, right, to operate under the prior agreement because you potentially knew that it contained things from the device.
Correct. I will say it would be incumbent upon us not to look at attorney-client privilege. And we did not look at attorney-client privilege. Whether it was incumbent on us to set up the same team is, I think, up for debate. Should we have done it earlier to make sure of? That's a good argument. I think you can make that argument, but I don't think it's definitive.
All right. Thank you.
Thank you.
Your Honor, there was some discussion about a next court date on the 9th. Do you recall that?
Yes.
I think the parties were going to request the 13th for availability reasons. Is that something the court would consider? Or is that not right? Did I misrepresent that? Okay, I thought, sorry. What day, Mr. Carodi is not available on the 9th, and,
Okay.
and I'm visiting someone in prison on the 10th that it took like I can't
Okay.
reschedule it.
No problem.
We could come back the 9th for Fernandez and the 10th for Gardner, or the 13th is not okay?
It's fine, that's the first I've heard of it.
Oh,
I thought we were gonna
okay.
split 9th and 10th.
Or we can all come back on the 13th.
I will do whatever y'all want to do. I'd rather do it together. What about the 8th?
Mr.
No, Your Honor, I'm out of town until the afternoon of the 9th.
So Gardner was driving a little bit of this, that you wanted time for the bond hearing.
Yes, Judge.
Give me just a minute. I'll do the 13th.
Yes, ma'am. Yes, Your Honor.
On both cases, that is, Mr. Fernandez and Ms. Gardner, the case will be set for going on motion. Let's strike that. On Mr. Fernandez, the case will be set for May 13, 9 a.m., going on motion. For Ms. Gardner, it will be set for May 13, 9 a.m., rolling on motion, then hearing on motion to be set.
I know it's a little early from the 13th, but the parties did discuss availability of Wednesday the 15th for that hearing.
I can let you know. I'll let you know on the 13th. I do, that other case I moved that had 3 co-defendants. I do have potentially 2 one-day trials, so. It would either, if it's going that week, it would either have to be the 15th or the 17th. One of those 2 days.
And the 15th
Well,
is the only,
Mr. Dreiser is looking. No, I'm saying, no, it's not you, it's Ms. Gardner. So she's the one that is, according to that team of lawyers, is concerned about delay. And so, I'm telling you what my availability potentially would be that week if, the Gardner team wants to push forward. It has nothing to do with you, Mr. Dresser.
I understand. Yes, Your Honor, understood. 5/15 or 5/17 as possible dates. We do
Right, So if
anticipate,
you would communicate
yes, Your Honor.
with, the lawyers in the case. And I know it's been the Gardner team's position this entire time, wanting to move forward with the bond motion even before the disqualification, so
Yes, Your Honor.
motion was heard, so all right. I'll see y'all then.
See you on the 13th. Thank you.
Thank you.
Thank you, Your Honor.